CPR 10.1 is concerned with the acknowledgement of service. 1. This part deals with the filing of an acknowledgement of service. 2. Where the claimant uses the procedure set out in Part 8. Alternative procedure for claims. This part applies subject to the modifications set out in Rule 8.3. 3. A defendant must file an acknowledgement of service if a. They are unable to file a defense within the period specified in Rule 15.4, or b. They wish to dispute the court's jurisdiction. Part 11 sets out the procedure for disputing the court's jurisdiction. CPR 10.2 is concerned with the consequence of not filing an acknowledgement of service. If a. A defendant fails to file an acknowledgement of service within the period specified in Rule 10.3 and b. Does not within that period file a defense in accordance with Part 15, or serve or file an admission in accordance with Part 14. The claimant may obtain default judgment if Part 12 allows it. CPR 10.3 The period for filing an acknowledgement of service. 1. The general rule is that the period for filing an acknowledgement of service is a. 14 days after service of the particulars of claim, where the defendant is served with a claim form which states that particulars of claim are to follow, and b. 14 days after service of the claim form in any other case. 2. The general rule is subject to the following rules. A. Rule 6.35, which specifies how the period for filing an acknowledgement of service is calculated, where the claim form is served out of the jurisdiction under Rule 6.32 or 6.33. B. Rule 6.123, which requires the court to specify the period for responding to the particulars of claim when it makes an order under that rule, and C. Rule 6.375, which requires the court to specify the period within which the defendant may file an acknowledgement of service, calculated by reference to Practice Direction 6b, when it makes an order giving permission to serve a claim form out of the jurisdiction. CPR 10.4 is concerned with the notice to a claimant that the defendant has filed an acknowledgement of service. On receipt of an acknowledgement of service, the court must notify the claimant in writing. CPR 10.5 is concerned with the contents of acknowledgement of service. 1. An acknowledgement of service must a. Be on the relevant form, b. Be signed by the defendant or their legal representative or litigation friend, and c. Include the defendant's address for service. d. Set out the defendant's name in full. Where the defendant's name has been incorrectly set out in the claim form, it must be correctly set out in the acknowledgement of service, followed by the words, described as, and the incorrect name. Rule 6.23 makes provision in relation to addresses for service. Rule modifies this part, where a notice of claim is served under that rule, to bind a person not a party to the claim. 2. If two or more defendants to a claim acknowledge service of the claim through the same legal representative at the same time, only one acknowledgement of service is required. 3. Where a defendant is a company or other corporation, a person holding a senior position in the company or corporation may sign the statement of truth on its behalf, but must state the position they hold.